Well, my watch says it's 8:35, so we'll go ahead and get started today. Welcome back. Appreciate everyone devoting another morning to the child welfare training and moving the dial. Nikki and I are going to start off this morning, I guess, talking about the question of why do Native American children stay in care longer. And before we do that, I guess I'd just like to reflect a little bit on what I heard yesterday. At least one of the most interesting things I heard yesterday is one of the panel members with lived experience described how helpful and what a resource the foster family is and was to him. And I was just really impressed by that. And I think some of us have had stories where that's not always the case. And it was just really impressive to me that what a great resource foster families can be to really get success. And then apparently continue to have relationships with the family and the child. So the more positive people in a child's life, the better things seem to go for folks. And so I just thought that was interesting. And we would ask that if any of you have reflections on yesterday that you thought was helpful, interesting, something that you just resonated with you, we'd ask that you please put it in the chat so that we can talk about it later and maybe expand on some of the things that are very important in future trainings. So I guess we'll get going. The question, why do Native American children stay in care longer? If Nikki and I knew, we would solve the problem and we wouldn't be here today, probably. I think it's probably multifactorial in that yesterday, I know in the group that I sat in with, people discussed a lot of issues that seem to get their case slowed down, everything from trouble with service. And I heard a lot about licensing issues, that a lot of potential placements are not able to get licensed, and that there's some preclusion on a placement, like grandma had some sort of criminal case being 15 years ago, but because of that, she's precluded from being a placement option or being licensed. Lack of services, delay of services, and the list goes on and on. And so it would be nice if we could distill it down to one solution or one problem and then correct that. But like many things in child welfare, it's multifactorial and kind of a domino effect at times. Nikki, maybe you have some additional thoughts on that, and maybe can tell us a little bit about some of the placement preclusions, and are there workarounds and things like that that might be helpful for people to know.
Sure. Thanks, Judge. So good morning, everyone. Welcome back, as the judge said. I think some of my thoughts just from yesterday was it's so impressive to me that we have like almost 100 people attending the Moving the Dial yesterday and today, and such a team approach on how we address this issue. Like the judge said, if I had all the answers or if she had all the answers, we wouldn't need Moving the Dial, and we'd have no challenges with kids in foster care. But obviously we all know that's not true. And so just my immense gratitude to all of you guys for continuing to show up, to continuing to want to improve the child welfare system in Montana. It will take all of us, and it will take us doing this the rest of our careers. So just wanted to thank you guys for it, because we have made significant strides over the past 5 years. And that's been about this team approach from all levels, from the court improvement program, all the individual judges and courts and attorneys and the Child and Family Services offices. I'm just super proud and excited to be part of this system in Montana. And when I think about yesterday, it was really helpful to hear from the tribal judge and from tribal attorneys, really about that belief in family, which I think is so huge, and giving parents every opportunity to be successful. But with that takes time, right? So when we think about Native American kids staying in foster care longer, the more opportunities we give parents to succeed, which is exactly what we want to do, it does potentially push out the timeline for kids in foster care. We also talked a little bit about, are all these timelines that the federal government sets for us, are they the right timelines? They are the timelines we have to, we get judged against, but maybe they're not the right timelines. So I think that was some good takeaways of kind of that never give up on the parents. But I also thought it was really helpful to hear from the panel around the kids' experience. So we heard a lot about how do we ensure that the parents stay connected and the kids stay connected to their parents, but really that piece of lived experience. And I hope we continue to do that, not only at Moving the Dial, but at some of the other functions that Child and Family Services hosts, that we always bring that lived voice and that lived experience to the forefront. Because it's easy for us to think we know everything sometimes when some of us, but most of us have not experienced what all of the folks, whether you're a foster parent, a child, or a birth parent, have experienced. So keeping that lived experience and that voice in front of this team, I think will be extremely helpful as we move forward. So again, back to that question, obviously don't have all the answers, but I'm pretty confident that between this group, and I know we have a community of practice around ICWA that the CIP is heading up, we have a lot of attention on the issue, and sometimes that's what it takes, right? It's just putting attention on an issue, and then we find ways to start to improve it. So just appreciative of the opportunity to have this in the forefront and continue having this conversation.
All right. Well, we have some.
Sorry, Judge, I did not speak about licensing.
Well, I just was curious if you had any tips for folks. Just, I know it's sort of off topic, but just tips as far as, because I know at times we have been able to get sort of someone approved that originally looked like not an option. And so if there's something that you think would be helpful to us there in making inquiry with the department, it would be nice to know.
Sure. So through administrative rule, we do have the option to create exceptions. We can make it child specific. And so if there is, I think there's a perception that, if there's an old substantiation, the team, the CPS worker can ask for an exception. We still have to ensure the child's safe. And we still have to comply with Adam Walsh. So we are not able, right, if something in someone's past is impacted under Adam Walsh, those are exceptions we can't make. But just a substantiation, I get the call or the email, probably one a month, with a grandparent looking for an exception for licensing or just for employment from a substantiation that happened years and years ago. So we do have the ability to do that through licensing. What I will say is this is a bigger topic. Some of our legislators are very excited or interested in this topic, and I would like to figure out a way to develop some administrative rules around expungement for substantiations that are not safety related, potentially, or situations have changed significantly over the past 20 years or so. So okay, we do have the ability to do that exception, but we have to still comply with Adam Walsh.
And there might be some people on that don't know what Adam Walsh is, so maybe tell them that.
So that is our federal requirement around ensuring that people who have child abuse or neglect or significant crimes against children are not able to be a licensed parent, foster parent, or adopt. And so I think it's just always have to keep that in the back of our mind, and definitely can talk more about this either at another Moving Dial or even at the local level. Our licensing resource specialist, our licensing supervisors are extremely knowledgeable about where exceptions can be made and where they can't. So can always have those conversations at the local level too.
So Kelly Sather has posted a question in the chat. Is there anything people could do individually to try to change the law, policy, administrative rules to make it easier to license kinship placements?
Sure. So there was just some new federal, and Kelly, you guys may know this a little bit better than I do, but some federal law and action around licensing kin and how to create a different licensing process for kin providers nationally. Montana has always held a very extremely easy process for kin. Like we are already make exceptions for a variety of things that other states don't. And so those new rules, we're looking at them, but most of them we already have in effect. An example being, in some states, you have a literacy test, right? Like a foster parent has to have some level of literacy. Montana's never had that. So our belief in placing with kin that we've had for, decades really has always approached it of, making sure that we do not create barriers through the licensing process, but that we do control for safety, right? We need to make sure kids are in safe placements. And so, Kelly, I think the pieces, what I'm hearing is we probably need to provide more education to everyone and more around our licensing requirements and the licensing process. And then where exceptions can be made. And so obviously did not prepare all of that this morning, nor do we have time, but can definitely provide more education around that and that information.
Right. Looks like maybe information about how to ask for the exceptions too, and advocate for that as well, so that we have those robust conversations going on. But I think that is a little beyond our topic today. At this point, what I'm going to do is turn it over to Kelly Sim with the Casey Family Programs to moderate and facilitate our next panel.
Thank you, Judge Gustafson. Good morning, everyone. My name is Kelly Sim. I'm with Casey Family Programs, and I've been working closely with Nikki as well as the CIP on really helping to partner with you all in improving the child welfare system as we know it. Our foundation is focused primarily on improving the foster care system, but in that we work with a lot of different sectors as well as all three branches. And so I just wanted to give a little bit of a brief description of who Casey Family Programs is. I always assume that people know, but I know there are newer folks here too that aren't quite as aware. And we work, in doing so, we work with all 50 states and DC, Puerto Rico, and US Virgin Islands. And as a part of that kind of reach nationally, we are able to tap into a lot of resources, especially for jurisdictions that are doing well in certain areas, and bringing folks together to learn as peers in specific areas. And so this morning, because we are talking about permanency, and especially permanency for long stayers and those who tend to be disproportionately represented in that population, which for Montana is Native American children. We had kind of looked through what jurisdictions were actually doing fairly well or improving as far as their trend lines go. And we were fortunate enough to make connections with 3 jurisdictions. First is Washington, then we have New Mexico, and we also have Pima County, Arizona. And so we we're fortunate enough to have our panelists here today. And really what we're going to do is do more of a presentation style for the first hour or so. And then we do have some time where we are going to be able to do a Q&A. So you can actually ask follow-up questions to their presentations. We are going to hold them all to the end of all 3 presentations. And then we'll have an opportunity to kind of get back to each of them with some of those questions that you might have. You can also put them in the chat, and I'll be sure to monitor those and make sure we get to them at our Q&A as well, so you don't forget, because I know I do in 5 minutes. And so I will try and make sure we address all of the ones in the chat first, and then we'll open it up for just, raise your hand and we'll be able to get to you and your question. So I think what we'll do is just go ahead and get started right away. And I am going to ask our panelists to introduce yourselves and what you do, what your role is within the jurisdiction, and then go ahead and do your presentation. So I am going to start with Doug and Corey. And Doug, go ahead and start your PowerPoint.
Good Good morning, everyone. My name is Doug Savaleski. I'm the QA/CQI administrator for state of Washington. What I'm going to talk about today is in Washington, we developed a statewide ICW case review process that has helped to identify both practice-related issues and systemic-related issues in relation to Indian child welfare. So I'll go through fairly quickly, like Kelly said, for about 15-20 minutes. I'll go through these slides, talk about our review process, and then Corey from Washington will talk about some of the research and the work that she's doing before we turn it over to New Mexico and Arizona. So we began our statewide case review process in 2005. We developed this process collaboratively with our tribes. So initially, our review process was very simple and straightforward. It was all about just making sure that we were following ICWA and identifying Native American families that were involved in our system. It was a very narrow scope when we first developed our review tool in 2005. Our first ICW review occurred in 2007. We had a follow-up review in 2009. In 2012, Washington passed a statewide ICW law in Washington, like many states have since then. So our review in 2012 then expanded and included elements of our state-specific ICWA law. And also in 2012, that review process was written up by Children's Bureau and part of their monthly newsletter. So it was recognized by Children's Bureau in 2012. And in 2015, Children's Bureau then sent a representative from Washington, D.C. to go along with us during our 2015 review. And they shadowed and learned about our process and took that information back to Children's Bureau in Washington, D.C. And then our last review occurred in 2019. So what is the purpose? So we really try to focus on these specific areas for our review: compliance with federal ICWA, our state ICWA, our tribal agreement, our state tribal agreements, and making sure that we're following our own DCYF policies is really the focus of our ICW review. So our review process, like I mentioned, the review tool that we utilize was developed collaboratively with tribes across Washington. Both the questions that we ask and our rating criteria of what's considered achieved or not achieved, all of that review tool was developed collaboratively with the tribes. So then our review process, we have 6 regions in Washington state, and we invite tribal partners and DCYF ICW workers to go to other regions and review the ICW practice and apply the tool. So when we review cases across the state, there's a tribal partner and a DCYF state partner that review every case together, and then collaboratively, they answer the questions on the tool based on the information that they've read. I will give another shout out to Casey Family Programs. So one of the barriers to accomplishing this type of review is that it's quite the hardship for a tribe to participate and be away from their jurisdiction for a full week for a review. It's also quite expensive for that tribe. Casey Family Programs has supported this review process over all those different years, and pays for the tribal partners' hotel room and their per diem. And DCYF as a state pays for the expense of the travel. So that's been a collaborative approach with Casey Family Programs to have these reviews occur each of the years. So like I mentioned, when the review process happens, we have partners from the state tribe that come and review the cases, our own DCYF workers, supervisors, managers, and then under my section, I have our statewide case review team. So even though we have different partners that go to the different regions, our statewide case review team is then that consistent continuity throughout the review process. So the statewide case review team is present at all 6 sites to make sure that there's some accountability for how the questions are answered across all 6 regional jurisdictions. If there, like I mentioned, there's collaboration on the answers to the questions. If there's disagreement between the tribal partner and the state partner, we then open it up to the entire room to have a discussion about that specific question, about the case that's occurring, and come to a consensus as a team about how a specific question should be answered for a case. Then at the end of the week, we do a debriefing. So we put away all the cases, put away, all the rating tools, and just sit down at the table and have a conversation about what did the reviewers see in reading these cases over the week in the practice that's occurring in that region. What systemic barriers were getting in the way of good practice, and what kind of improvements needed to be made to improve outcomes for ICW families in that particular region. We also open up that discussion to, since folks are coming from outside of the region that they're reviewing, we also then open that up to a discussion of what are they experiencing back in their home jurisdictions? What kind of barriers, what kind of systemic problems are getting in the way of achieving good practice? One of the things that we identified in 2019 was around our in-home cases. So I know you're focusing on permanency and moving children to permanency, but for our in-home cases, one of the things that we identified as a systemic factor in Washington was that we did not have any Native American providers for our evidence-based programs that were going into Native family homes and providing services. There wasn't a single provider across the entire state that was Native American going into Native American homes. So that was identified as a systemic factor. We've since provided that information to our service array folks that are working on building those contracts and partnering with tribes to develop some of those in-home service programs and improve our evidence-based programs. We have 8 areas of focus. There's our current review tool with the way it sits. There's 43 questions. So these are the 8 different areas that we review. Like I said, 43 questions across these 8 different areas. As I mentioned, we identify both those regional trends, the systemic issues. We do that debrief, and then at that next day, the very last day of the week, we do an all-staff meeting for that region and kind of talk about the trends and the themes that we saw in the practice in their specific region. And those are presented by both the tribal partners and the DCYF partners that talk about those themes and trends. With the staff. We develop a regional report for each region that again identifies what was the practice that we saw in that region, what are some of the systemic factors that we saw that was impacting, and then we develop action plans for each of the regions. And then we also have a statewide report and action plan that comes out of that process as well. So bringing it back to the permanency discussion, I did pull these numbers from our last 2019 review. So when ICWA was applicable, statewide, we reviewed a total of 62 children. that average length of stay was 21.5 months, 21.6 months was the average length of stay for those 62 kids. By way of comparison, in 2019 for Washington, for all children in care, I believe our length of stay was right around 510, 525 days, and 21.5 months, I did some math, is right around 650 days. So an additional 110, 120 days in care for these children that were reviewed that were applicable for ICWA. In our review process, we do look at both ICWA cases and non-ICWA cases to make sure that we are doing the work to even identify when a family is applicable for ICWA. So out of all the cases that we reviewed in 2019, this was kind of a breakdown of our average length of stay for the different age groups. And probably not surprisingly, as children are older, their length of stay increases. That's my overview of our review process in the state of Washington. I will turn it over to Corey. Corey, I'll go ahead and run these slides for you.
Perfect. Thank you. Good morning, everyone. My name is Corey Campbell. I am the Indian Child Welfare Evaluator for the Office of Innovation, Alignment, and Accountability at DCYF in Washington State. So this is a new role that was created and I was hired for in April. So I really think that one of the things that Washington is doing is adding a lot of workforce around this issue of ICWA and our practices and policies. So hopefully we continue to see some positive changes and growth. So just building off of what Doug was talking about, I'm also going to throw in a link in the chat to the Washington State Disparity Indices report from 2019. So you can see some of those comparisons between our Native populations and other child welfare populations, if that's of interest to you for later. But one of the things that I wanted to highlight in my work and the Washington State work is our reason to know standard. So in 2021, the Children's Administration and DCYF changed what we're doing with Native children. So we have this reason to know standard. I just have a little quote up here from the mandate in particular. But when CA receives an initial intake regarding allegations of child abuse and or neglect, the intake worker and the local office CA caseworker must determine if there is reason to know that the child is or may be a member or a biological child of a member and eligible for membership in a federally recognized tribe. So this really has some deep implications for our practices, because when reason to know is a concern, then we are using these ICWA policies for these children before they're confirmed by NAIR or any of our other practices. So we're really using ICWA very broadly in Washington State at the initial intake, so that we can ensure that these children are being cared for the way that our policies have been set up. All right, if you can move forward for me, Doug. So then in addition, we've also had a lot of changes to our practices and policies. So some recent changes that we've had are the implementation of active efforts, and specifically, thank you, Doug, and hiring some active effort specialists. So this, and additionally, those are some things that the practices and policies of ICW work in the state of Washington has gone a major overhaul in the last year, where there were tribal consultants and many roundtables where we were discussing all of these practices and policies and the changes. So these are very, very new to Washington State changes just this summer. So we're going to be monitoring how these changes have impacts on our outcomes for children and families across the state. Then we have increases in caseworkers for ICW cases. So our workload studies and the number of ICW caseworkers have also increased. And then finally, I think this goes towards the conversation that you all were having this morning. So we have expanded and changed our guardian assistance program. So that is in relationship to the funding that we can give to families. And then also we've really recently changed our initial licenses so that families can have, I believe it's, they can apply for a 60-day waiver so that they can get that license so that they can have that kinship care placement with the funding. So I don't have a lot to go over, but I will send you links, especially as it changes over time. And I see the comment, we don't have a more recent one, but I'll have one next year for you, Steve. All right, if you can go to the next slide, please, Doug. Thank you. So my role is really in the research and the evaluation of these programs and the practice changes. So the things that I'm kind of looking for over the next year and years will be around how the implementation of active efforts and hiring these active effort specialists might increase our service referrals and offerings. So again, going back to what the judges were talking about this morning around services provided. And then also increase case planning with families. So if we're thinking about how we can maintain permanency in these families' homes or in their extended care networks with some benefits being towards those children. All right, if you want to go to the next slide for me, thank you. And then with caseworkers, we're hoping that there's a reduction of workforce turnover, that there are improved trends of moves per 1,000 days in care, and then again, reduction in reentry and placement changes. So really those length of stays, if those are, I think this kind of talks to when children are in foster homes that do seem to be providing that level of support that they are needing, then if we can keep them in those homes for longer, that seems beneficial. All right, and just the last hypothesized output. So guardian assistance program. So this is for funding for any guardians of children in our care. So hopefully we're hoping that increased dollars distributed to families has impacts on children's well-being. And then also that it decreases their length of stay within our care. And then finally, the well-being generally to children's well-being. So we're going to look at that after 6 months. And then I have 2 more links for you all. There was, because one of the things with reason to know is that this also means that even though there are some youth that are not in federally recognized tribes, we do have a category, a demographic category that we have place them in, so we can also track those numbers as well. And that kind of brings up some of our disproportionality indexes a little bit higher than what you might see in federal registers. So with the AIN multi category, they have pretty similar populations to our Native families and they have similar outcomes, unfortunately. So we're hoping that these expanded policies and practices have an impact on all of our Native communities. Yep. And let me see those links. And yeah, turn it over for questions.
So Corey, we're going to hold the questions until the end. Yep, until everyone's done the presentation. So if you have questions out there, please put that in the chat or hold on until afterwards, and then we'll get to those. Okay, I think we will move on now to Judge Bostwick. If you could also introduce yourself and then go ahead with your presentation as well.
Thank you, everybody. Thanks, Kelly. I'm pleased to be here. Washington is such a leader in this area, and I've already learned a lot today by what you shared. and learned yesterday by listening to some of the programs. So we already have some new goals here from preparing and listening and being able to collaborate with you all. So thank you, Casey, for all you do and for inviting us to share and learn today.
Judge Boswick, just before you get started, I don't know if it's just me, but I see sort of a different view rather than just the
Okay.
big slide presentation.
Let me unshare and see what happens there.
Okay, try it again.
Okay. Was it anything interesting?
No.
No.
It's just the main, and then there's another little one on the corner,
I
right?
think
So
it's your
not the-
second.
Oh, yeah, I
screen
see what you're
showing your
saying.
notes and stuff, so.
How about
There you
that?
go. There you go.
Perfect. Thank you.
Mm.
So looking from a Pima County ICWA Court perspective, it is all about collaboration, which is what all this is about. And I think that's relevant to our perspectives on permanency and our processes, really our approaches, because we make decisions together. We formed the court together with tribes, lawyers, Casey, of course. We had someone from the university helping us who's an Indigenous law expert, and the court was created in January of 2020 that way. So some of the things we've done that we think help expedite permanency, but most importantly, the right kind of permanency, which we're all still learning, are to create some teams so that the caseworkers who are in ICWA cases are now knowledgeable about ICWA, an ICWA unit at our Child Protective Services, which is Department of Child Safety. We have certain attorneys for the parents and children, as well as certain ICWA judges. However, we consider our whole bench an ICWA court. We have a number of judges on the juvenile bench. 2 of them are really the primary ICWA judges, but all 12 to 14, depending at any time, are cross-trained in ICWA, and we share at ICWA in our bench meetings. And actually, there's a lot of excitement and interest about ICWA across the bench. One of the great changes that we think also helps get tribes in early and involved and avoids delay and helps inform permanency is getting tribal caseworkers in. Having an ICWA court has increased tribal interventions, especially from our main tribes, and attorney participation, but we also put the caseworkers on our minute entries for distribution. Caseworkers get disclosure. Caseworkers appear on the court calendar, though they are not lawyers or, usually you can't be self-represented for an organization. They're there, their voice is heard, even if an attorney can't be here. And even when their attorney is here, they're crucial. Tribal holidays are in our calendar, so we don't conflict with them and respect them. And we have blocks that we preset just for ICWA cases on the court calendar. For example, that first very important preliminary hearing, we call it the PP5 or PPH, the first protective hearing when it's terrifying and the removal has just happened. We part of it, very sure we can get the tribal presence there. Another change, which we'll talk about in a second, because I think it does help with permanency and avoiding length of time in care, we hope, is we have with our primary tribes affidavits they can use in place of testimony. This was their creation, Pasco Yaqui tribe. So if the parties, the parents are at mediation and we're getting off to a good start, or hopefully something is happening by way of resolution there potentially, then we don't wait for another hearing on a very busy docket. The tribal caseworkers there, the affidavit is presented, and they can make that finding we need, send it to us to approve. We can, in other words, adjudicate quickly in those cases. I have yet to have any attorney object to one of our caseworkers or social workers from the tribe's affidavits. You would think they would get a lot of cross-examination. But a benefit, as you've probably seen in your ICWA courts, is that when the attorneys, the DCS, very knowledgeable attorney included in the courtroom from the Attorney General's office, when they all know these caseworkers, they know they're experts, they know they're in the home, they know what they're doing. They do not cross-examine and dispute the testimony, very rarely. Honestly, not always at severance either. So just sharing that that's a very effective trust building and trust tool. The community relationships and building the trust are crucial. Part of what we do since the start is to involve Casey, Sheldon Spotted Elk, collaborating and connecting us with people all the time, really building everybody's courts through Casey. We have monthly webinars to which you are invited, where other people share and teach us about culture and processes. And we learn about our tribes. We learn about how to do the best job we can for ICWA and families. We have group meetings, a couple to 2 to 4 times a year with anybody who wants to come, including our close associates and stakeholders. And we have some informal court-to-court contacts with other courts to learn from each other. We really enjoy that. So the demographics of disproportionality. Here in Arizona, we have 22 federally recognized tribes. In terms of actual tribal population, it's one of the most populous states, not by percentage, but by number of Native Americans in the censuses. Now, as you know, censuses tend to underreport Native people. I don't know that we trust census in a lot of ways, but that's the data from the census. And at the beginning yesterday, we're shown data about different states and disproportionality. So roughly 5 to 6% of Arizona is American Indian or AN as they categorize. And here in Pima County, we have two major tribes, Tana O'odham and the Pascua Yaqui tribe. And we see them in court the most, but we get many tribes, of course, in court. We were the first ICWA court in Arizona, but we do think that processes and perspectives on permanency are still being advanced by a second ICWA court that we now work with in Maricopa County, which we call up the road, which is the Phoenix area and the most populous. So in Pima County and Arizona in general, I took a look at the demographics. So it's like 4 to 5% of Pima County is reported by census as being American Indian, Alaska Native, but I looked at the schools too. I found an interesting public school report. It only reports on the percentage of Native students in public school, and it's only grades 3 to 12. But it was still really interesting to read about. It said about 3% of students in Pima County are identified as American Indian, and I think that's probably a little higher than that. But just for perspective, that's what's reported. So generally, Arizona's disproportionality rate is 1.5. That's considered low, also unacceptable, of course. Here in Pima County, just for an overview, we do have 145 ICWA cases right now, 285 ICWA children at this moment. We do snapshots of our data over time. We started doing quarterly snapshots just for an overview while we track some other details as well. Our data experts are incredible and crucial. And we will show you some of those snapshots in a moment. But in terms of length of care, of our cases overall, this is including all cases, not just ICWA broken out, about 27% remain open for 2 or more years. And the national average that you were talking about yesterday for how long a case is open, I think was 547 days. And we just heard about the ICWA review numbers, but ours is 551 days. But again, that's for all cases. That's not just for ICWA. When we started tracking, yes.
Sorry to interrupt, but we want to see all of your slide, and there's a little reminder, Outlook reminder that shows up. Oh. If you can just dismiss that.
I will.
Awesome. Okay, now we can see it all.
That was a big to-do list. We don't want to think about it. So on the Pima County ICWA court data, I put people next to that slide because it's really not about numbers, it's about people. And we always keep that in mind. We looked at and have sort of data reviewed time for permanency, time and care, but we don't have the ICWA breakout yet. That's one of our goals to work on that you are helping us with through this process. We look at our permanency, what our processes are, how much our tribes participating and intervening. We have a huge goal with regard to placement. We're trying to data track ICWA compliant placements. We track active efforts and how often that finding is made early in a case. And we also have our courts, administrative office of the courts that reviews us for compliance periodically. And we had 100% finding of, did we make the active efforts finding? So that's good. So that tracks us as well. And we're looking at how much are we seeing reunification, guardianship, or adoptions in our cases. This is most recent data. In general, again, this is overall to give perspective overall on average days and shows you that 27% or so of our minors, almost 28, have been in cases more than 2 years. So not most, like 73% are not, but that's a fairly substantial size in my opinion. So here's a snapshot from July. Say we did about quarterly, so I'll just show you one from July, show you one from October, and tell you what we're working on for the next time as well. This will show you that we have most of our tribal presence from the Tana O'odham Nation. They are geographically also our our home tribe in many ways, also the Pascua Yaqui tribe. So their percentage of cases, 15% for Pascua Yaqui, is a lot lower. They are a very active tribe in moving forward on ICWA matters. They collaborate with us and with the Tana O'odham Nation regularly. They present an enormous, amazing ICWA conference every year to which everybody's invited. I encourage you to come. And we have found with these two tribes, we really have a beautiful partnership for advancing ICWA in this community. So you can see here, we talked about Pima County being maybe 4 to 5% Native in the school population, probably about that. And that's a fair number and a fair estimate. But look what, we had 12% of our cases being ICWA in July. So that is disproportionality. We shouldn't be having that many. We should be having, even if we're disproportional, it should be less. So that's a reality. We noticed that with regard to the compliance with dependency adjudicating standard, meaning how do you adjudicate your dependency, find and adjudicate dependency, as you know, timely within time standards for the state. That is only done about 78% of the time when we started. But you know that we know some of the reasons for that, and we'll talk about those. You know them as well. You need a qualified expert witness to do that adjudication, and you may not have one in court despite the certified notice. You may not have one available because the tribe hasn't responded yet. Maybe DNA testing is going on, and they need that in order to decide whether to appear in court. So diligent efforts are made, but sometimes it is just not possible to adjudicate timely. Those timelines don't necessarily work that well in ICWA cases, but we strive for them. So the percent of closed cases is what's in the upper left here. That's, again, you know, we have about 10% of the cases that we've closed that were ICWA. So that is showing the disproportionality again. I'm going to pull your attention to the reunification rates here and non-ICWA and ICWA. So as of July, we had more reunifications at that point for the year in any event than in non-ICWA cases. And we could see down here on the chart that's a little square below the reunification exact percentages that you see above, but also the guardianships. So twice as many guardianships in ICWA cases than in non-ICWA cases, as to be expected. We keep moving forward in data and keep tracking it, and it changes not much in terms of the percentage of the disproportionality here, how many ICWA cases and non-ICWA cases we have in Pima County. And again, the adjudication timeline is just not something that works the same way for an ICWA case as it does for other cases. So those are continued concerns, but what we found in October is that we've had a flip-flop here. We still have this disproportionality, slightly increased even, of our percentage of ICWA cases, but we don't have as many reunifications now in our ICWA cases. This is just an ongoing thing, as in non-ICWA cases. So we wonder why. Well, we've seen the percentage of guardianships go way up. It jumped in those months. So we had a bunch of closures by guardianship from 16% to 26%, and that made a difference in how we're seeing these. So month to month, we can see trends, but we're working on getting a solid pattern to understand it. The case closures. So just to show you real quickly, these are about children in all cases who have been active for 2 years or more. So you see a lot of them end up closing by adoption, most of them, and we still have some guardianships after 2 years. I perceived a lot of these cases might be some of the children who are older and in the, adult living plans and so on, or delays in adoption for the reasons, we're talking about earlier. For some reason, the licensing isn't working and they're not getting the approval for that final adoption, but we're still tracking and trying to find the whys. And of course, the whys are incredibly important. We need to understand how to measure success under ICWA. Why is this happening? And what does it mean under ICWA? Not just under all cases, but under the goals in ICWA. And that includes understanding what does permanency mean to the tribe. And that has been an eye-opening experience when you compare these cases to the rest of your dependency caseload. We are hearing from the tribes, and we are experiencing and finding out in court from our tribal attorneys that the goal is really, on the end of the day, what's best for the child and keeping that child in culture. So for example, the Pascua Yaqui tribe, as I'll show you, they consider a success a guardianship or reunification, because family, relatives, culture are all part of family and their culture. So by looking at what is permanency, what permanency should look like in an ICWA case, we know tribal voice is critical, that they not be severed from the tribe, even if they cannot be reunified after active efforts with the parents. So if they can be maintained in the tribe, yes, at least in culture. Guardianship, a success. And if the adoption is into a tribal family, we're starting to document that, because we know that's different than a separation in a non-compliant household. In Arizona, one of our tribes has what it's called traditional adoptions, by the way, and not a lot of tribes do, some do. So if they do that process, then an adoption happens, but parental rights are not severed. It's a tribal court process. So that's good. It's very good. And that can't happen without the cooperation of our court, and we cooperate in that process. It's interesting to watch. So we're looking at, is permanency happen quickly? We work on it. Active efforts, though, can take time. That's part of making sure everybody has the opportunity to unify in the services they need. But we have managed to increase presence through all the ICWA courts, I know, and intervention in cases here. The court knows that permanency takes time. We know we need early good placement. We just have recognized that sometimes the standards for time don't align with adherence to the gold standard under ICWA and best practices. We need to let people reunify through getting the services and the opportunity. You all know these things that we are really contemplating daily too. We know that we can try to expedite things, but we can't skip things. That's not gold standard. So we must allow resources, even in a rural area where it's harder to get, to come through. Our tribes have great cultural resource programs, substance abuse treatment for Native moms and dads and homes and recovery. It's excellent. We also have set our goals to learn more about long stayer cases amongst other goals. So we're going to work on breaking down how long someone's here by ICWA case and by the type of closure we end up, the type of permanency and outcome. We're also working so hard here with our community in general on identifying services, even getting some into incarcerated places, culturally appropriate services. So tribes are very, very focused and motivated with providing services. Here's Pascua Yaqui's data. I bring this up just to point out that the percentage of guardianships and reunifieds, they look at guardianships and reunifications with a positive lens and combine them as a measure of success. And we've talked with them a lot about that, and all the tribes prefer guardianship here culturally, but since that's not the way standard data is measured, it's a special consideration for everyone in all our ICWA cases. Judge Quigley here is the judge who really started ICWA court, and she's another primary ICWA judge here. She and I have enjoyed working together and hope that our ICWA court can always keep growing through opportunities to meet with all of you and everybody who wants to help promote ICWA, involve different steps and different strategies that might help our children and community and families. One of ours, as I mentioned, is these trainings that we do monthly. We don't do it in the summer because we all feel here we can have excuse for like just putting on the air conditioning and maybe going out of town for a couple of weeks to somewhere cool in the summer. Beautiful here right now, by the way. But from September through May, we do these free monthly webinars. We don't present them, we facilitate them, and our administrative office of the courts at the Supreme Court supports it and assists in providing invitations, which I hope you've gotten and we'd like to send to you. This is just a shot of some of the ones we've done so far this year. They've been going on since 2020. We have one in a couple of weeks on December 13th on trying to create a peer support program here with tribal mentors for parents that have succeeded in the system as tribal members that can help the parents that are in it now. So these programs, you may have one, are very successful elsewhere. And we're excited about the possibility that might mean for helping achieve the right permanency for the child and in a timely way. So please join us for those if you'd like to do so. And thank you again for the opportunity to work with all of you on this. We're going to use the takeaways from today to inform our processes and keep moving forward. And I find it the most exciting work, and I'm humbled and privileged to be a part of ICWA Court. So thank you. Thank you, Casey. Thanks, Kelly. Thanks everyone for helping us learn.
Thank you so much, Judge Bostwick.
Mhm. You
Gosh,
bet.
I actually wrote
Oh,
down
sorry.
questions myself, but I'm gonna hold on that, and we will move then next to Lindsay.
Hello, sorry, make sure I'm unmuted. So I'm gonna share, I don't have quite an extensive of, I don't know what it's telling me. Sorry, okay. Are you seeing the full
Yes.
screen? Okay.
Yep,
All right.
looks good.
So that's just my name and my state. So I'm Lindsay Fuchs. I am a children's court hearing officer here in Albuquerque, New Mexico. So Albuquerque is our population center of New Mexico, and it is physically, geographically, just about the center of the state as well. And we have the highest number of ICWA cases in our jurisdiction in New Mexico. There are some jurisdictions that probably have a higher percentage of their cases are ICWA cases, but by sheer numbers, Albuquerque has the most. I support our presiding children's court judge, Catherine Begay, in our ICWA court that we've established here in Bernalillo County, which just is Albuquerque. And it is the only one in the state of New Mexico. And I think it was the 6th in the country when it started. We started also January 2020. So that's interesting to hear, Judge Bostwick, that you all started, it sounds like, at the same time. But I think there are many, many more now. We're coming up on this coming January, next month will be 4 years that our ICWA court has been in place. So I'm going to talk a little bit about that here. I'll go to my next slide. You don't have to look at my, my name for too much longer. And so I just wanted to talk first about kind of the things that I think are sort of guiding some of the successes that we have had with ICWA cases and ICWA court. I'm going to talk a lot of the information I have and a lot of my experience is Albuquerque specific, ICWA court specific, but there is some statewide information as well. So obviously we practice under the Indian Child Welfare Act and have since what, 1978. But I will say that our Judge Begay, who is our ICWA court judge at this time, has really been a champion for ICWA, both when she was a practicing attorney in front of our court, when she was a hearing officer, as I am now, and since she's been on the bench. And really the initial goal of our ICWA court is just to ensure that families and children are benefiting from the full protections of ICWA, and that it's not seen as like, you know, extra hoops that have to be gone through or a burden or things of that nature, but it is a level of protection for our families that they deserve and that we are required to follow. So this is my slide sort of out of chronological order, but so I stated in January 2020, the ICWA court started here in Albuquerque, but certainly a lot of work went into that before the ICWA court was able to jump off. So I know that here we did, or not we, I wasn't part of it at that time. There was a full case audit of every single case in our county to ensure that ICWA determinations were made in each case. We actually filed in each case a judicial determination on ICWA. And so there's, you know, that's easy in most cases, right? Yes or no, but there are certainly some that require more investigation, more tribal contact. And so that was done also to ensure that we had the numbers to justify an ICWA court. And so when the ICWA court started, before it could start also, there was extensive collaboration, much like Judge Bostwick just talked about with, I always love the alphabet soup of our different agencies. but we are CYFD here. So collaboration with CYFD, with the tribes, and with our administrative office of the courts, who at that time were contracting with our attorneys representing parents and children, and KC Family Programs was provided a lot of guidance on that too. So once it got established again, and we were just practicing under ICWA at that time, CYFD had developed a specialized unit, permanency unit, with a supervisor, and all of the permanency planning workers were Native American. And they had their own internal specialized training, as well as joined specialized training for the court and other attorneys. That unit also included a children's court attorney from CYFD that was assigned to ICWA cases. Like I said, specially trained attorneys that regularly practiced in the children's court in all cases, but then began specialized training for advocacy for Native families under ICWA. Also, regular staffings. So we, in all of our ICWA court cases, we have regular staffings. This is one of the pieces when we talk about, my understanding is you all have had conversations about things that you can do at the beginning of a case, and that we're here today to talk more about the permanency piece further down the line. When our ICWA court started, the staffings were monthly. I think that they don't do that necessarily anymore, because they do it really more as it is believed to be needed. But those staffings include the attorneys, the court, and the tribal representatives. Our ICWA court has ICWA court program manager. Her name is Megan Gonzalez, and she leads those. And there is sort of a worksheet that they go through for each of those staffings. It's not on the record, but everyone's getting together on a regular basis off the record to kind of check in. Where are we? Everyone leaves with action steps to move the cases forward. And I think that those regular staffings are something that can really help in identifying kind of we talk when cases get stuck, like how to get them unstuck. And much like Judge Bostwick talked about as well, we have regular specialized trainings for all parties that are involved and all roles that are involved in our ICWA court. Those are put on by different entities. So the court leads some of those, the agency leads some of those, the tribes lead some of those. And so that is our ICWA court. And then in 2022, our state ICWA, which a lot of states have, which we is titled here, the Indian Family Protection Act, was passed. So I also think that the work that was put in to draft and pass the Indian Family Protection Act has just rippled through our community in really kind of fortifying and lifting up tribal collaboration. So in New Mexico, we have 23 tribes, pueblos, and nations, and every single one of them had a hand in drafting our Indian Family Protection Act. We have a consortium. It's titled the New Mexico, we call it NMTIC, but New Mexico Tribal ICWA Consortium, that sort of led the drafting. And I really think there was a version that our agency CYFD tried to lead that did not get passed in the first time court. I think we called it ICWA, like state ICWA. But that did not pass. And I think when they went back to the drawing table, our agency took a step back and really let our tribes lead the drafting of that. I just think that it has brought leadership together amongst the tribes and a collaboration that we have continued to benefit from, and our children and families have continued to benefit from. And so it's one of the things that I've heard from both earlier presentations during this panel, and I think we have sort of resounding as tribal collaboration, tribal collaboration, tribal collaboration. That's been huge, I think, in moving cases forward. I also want to let you know in our ICWA court right now, I reached out to our ICWA court program manager. I don't have a lot of data in my slides. I just have one more slide. But right now, as I speak to you, we have 29 cases in our ICWA court, and we have 47 children. Not every ICWA case in our jurisdiction is in ICWA court. Everyone that's came to us from January 2020 on is in it, as well as there have been some older ICWA cases that there is sort of a process for attorneys to kind of reach out to the ICWA court and apply to have their cases as part of the ICWA court. So some of the older ones have been pulled in, some have not. Sorry, I just want to make sure I'm checking my notes. Oh, the other thing I wanted to note is that our ICWA court program manager also does some data gathering. I don't have that to share, but having a data plan and a regular data evaluation and keeping that data has been important as well. And one of our things that I think that one of our major successes is in this almost 4 years, we have not had any termination of parental rights. And so that is something that our group, our court is really proud of. I wanted to also note that as part of the Indian Family Protection Act, it required mandatory judicial training on the new law, and that was held over the course of a day and a half, and it was held on Indian land at our Saleta Pueblo here in New Mexico, and it was led by the ICWA tribal representatives that we see in court representing their tribes. And so it was really unique. Of course, all other stakeholders collaborated, but when you were in that training, they were the ones up at the podium that were leading. It was very different than I'm used to as an attorney or a judicial officer, the type of kind of really more, I don't know, just methodical training. It was much more open and very fun, honestly, and interesting. And I really it just opened my eyes to the benefits of having, you know, our tribes lead us in that education rather than us being such attorneys all the time. And so that was a huge benefit to us as well. The other thing is that during the course, of course, of our ICWA court, the Indian Family Protection Act did pass. And so we had to incorporate all of that into our ICWA court policies, procedures, and things of that nature. I think that I've been told, I understand that Montana has its own state Indian Child Welfare Act as well. And a huge benefit of ours is that it just has really, you know, it's given us definitions on things that were so kind of loosey-goosey and or up for interpretation. It's made certain things very clear. It has the ability for invalidation on, like, I don't know the number off the top of my head, but I think it's about, 20 plus different points in a case if there are not active efforts that parties can move to invalidate that state action. And so it is intensive, and it's, I think, really brought a good focus to Indian children. So my next slide is a kind of just a list of things that I think New Mexico has done that are tools for permanency for our children that may, I don't have the data or performance measures to, pinpoint what New Mexico has done that maybe other states haven't, that is leading to us not having the same disparities. But these are some of the things that I believe are tools. So first is, I think, our ICWA court here in Albuquerque, but also Judge Begay and our state judicial leaders have really worked to try to share lessons from our ICWA court. Many of our jurisdictions do not have a number of ICWA cases to justify a full ICWA court. But that doesn't mean that we can't share some of our lessons statewide that they can take, 1 or 2 or 5 or whatever that they think could work in their jurisdiction. we have, like I said, just a heightened level of collaboration since the ICWA court has been put in place. And I would say that's not just tribal collaboration, though certainly that is true, but also court, CYFD, attorneys, families, intertribal collaboration. So it is not uncommon that a child or a parent will have, heritage from multiple tribes. And of course, they can only be members of one tribe at a time, but that doesn't mean their relative who is a potential kin placement is not necessarily with another tribe. We've really been able to sort of step back as the court and attorneys and let the tribes work together to figure out maybe which tribe or pueblo the child should be enrolled with, or how they can pass along things like a home study of a different tribe or things of that nature. So there's been a lot of intertribal collaboration. And again, I think that that is one of those ripple effects of the New Mexico Tribal ICWA Consortium and the drafting process of our Indian Family Protection Act. Built into our Indian Family Protection Act are cultural compacts. So if a child is being adopted or a permanent guardianship is being entered outside of their home that is not part of their tribe, whether it's another tribal home or a non-native home, our law requires that they enter a cultural compact, which ensures that the adoptive or guardian family will continue to honor and engage the children with their culture. I've seen mediation done to ensure that those are done, and sometimes they're done without mediation. We have a family finding process. Family finding meetings are sometimes ordered here, so that ordering CYFD essentially to invite like every family member that they know of the child to a family finding meeting, and building out and building out and building out what that child's family looks like. I remember part of our IFPA mandatory training, one of our tribal leaders saying, we have family. So don't let anyone say we don't have family, we have family. And it is our duty to ensure that we understand who that family is. And again, when we're talking about tools for permanency, continuing to grow an understanding of that child's family is very important. Out of placement preference staffings. So this kind of goes with the next one, which is the Office of Tribal Affairs. Our Office of the Secretary has established an Office of Tribal Affairs, and that Office of Tribal Affairs holds monthly out of placement preference staffings. They call them OOPS, but children who are placed out of the statutory placement preferences, there is a meeting internally at CYFD on a monthly basis to evaluate who has been contacted, how we can, how they can find a preferred placement for the children. And that's built into our Indian Family Protection Act, that those staffings are to happen on a monthly basis. And they have a tool that they use that they go through as well. Tapping tribal resources. So, before Office of Tribal Affairs, I will also say they do a lot of great work. They are fantastic in when we have a case with a tribe that, we're not super familiar with, that we don't engage with on a regular basis, even out-of-state tribes. I've had two recently from Minnesota. They do a really great job on assisting us in reaching out to those tribes, make sure we're identifying the correct person to reach out to, getting responses from those tribes on whether or not the children are eligible or members of the tribe. And they also put on an annual ICWA Summit. It's always the Tuesday after Indigenous Peoples Day in October. I think we did the third or fourth annual one. But it's a statewide summit all day that is really tribal led and tribal focused as well. Tapping tribal resources, ensuring that we are engaging our ICWA tribal reps, for me in court, but also for the parties outside of court when we again find ourselves in those situations where we're stuck. Do the tribes have resources that they can provide to the family? Peacemaking and other tribal traditions. We did have a case recently where peacemaking was used to resolve some issues so that the child could have permanency, and everyone was really pleased that, again, we were sort of able to step away as the court and allow the family and the tribes to engage with their tribal traditions to resolve issues and to come up with plans for children. Active efforts at very early stages of the case. So again, we're talking about permanency, but I think that continues to ripple through cases. Especially since our Indian Family Protection Act, we have been just hammering away at those active efforts, what that means, where there are gaps, what needs to be done, really working. I will say here in New Mexico, we had a grant-funded program that was used off the model. I think it's in New York, the cornerstone of advocacy. And one of the big pieces is that those first 60 days, and that is something that has really stuck with our community. And we continue to really push for those active efforts. The earlier, the better. So I said recruiting Native American CYFD staff, attorneys, support. I want to say that our child welfare system in like this 2023 has had a lot of challenges. We've got a new secretary and administration. There was a hiring freeze. So as caseworkers left, new ones were not hired for a period of time. There has been a lot going on, but in my sort of anecdotal experience in our ICWA court and with our ICWA cases, you just can't, there is a credibility that Native American, not necessarily, of the same tribe, but engaging, recruiting and understanding the importance of that, having Native American staff and participants in all roles is truly beneficial. I've seen a case, I swear it's for 2 years it wasn't moving, and then one of our real champions here in New Mexico, who is Navajo, was able to as a permanency planning worker, just a line worker, really move that case in, I swear, like 30 days. We had relatives, we had connection with dad that hadn't been there for years. And so with this, I would also say really identifying the champions within our system. Our CYFD ICWA court unit doesn't look like it did when the ICWA court started. There has been a lot of change. But there is one individual who, I don't know that anyone here would know, his name is Windsor Yazzie, and he's an absolute champion for the entire state. When anyone asks questions, he has total buy-in by so many tribal partners. I think another thing is really identifying your champions and supporting them as much as you can. And then I think I've talked about the tribal-led training. One of the things I wanted to say too that I heard some people talk about was, and I'm sorry, I think I'm running over on time, but New Mexico has I believe, an intergovernmental agreement with the Navajo Nation that does not require us to do ICPC with the state of Arizona or Utah if children are placed on the Navajo Nation. And so things like that, when we talk about licensing or kin placements, half of our ICWA court cases are Navajo. And so things like that can really cut through some of the red tape that is required for permanency, for placement with kin and things of that nature. So I don't know if you all have any of those in Montana, but I think that, like I said, 50% of our ICWA court cases are Navajo, and not having to do a full ICPC process, I think, is significant too in reducing the time to pregnancy for children. So I am going to end there so we can have some additional time if needed.
Awesome. Thank you so much, Lindsay. I love your last slide. It has so many great nuggets that I think we can walk away with. Before we go into the Q&A, oftentimes when I do a presentation, I always go, oh, I should have said that, right? I miss saying this. So I want to bring it back to the whole group to see if there's anything that you wanted to say that you didn't get a chance to say or mention that came to you as you were listening, or even a response or question to any of the other panelists among you. So yes, Judge Bostwick, go ahead.
So just wanted to mention that one of our projects here is to work harder on early intervention, which is something we learned a lot about from court in Duluth, to make our treatment court, which Judge Quigley, one of the ICWA judges here, is now running, more Native friendly, more inclined towards parents from ICWA cases, or even if not ICWA cases, tribal parents, and including RSS, recovery support specialist who's tribal. We've learned a lot about family treatment court from Yellowstone County. I saw Brooke is here from Mural's court. And then aftercare services, meaning, recovery capital, where your services and resources are right so that we don't have reentry. So if anybody ever learns more about tools in that area, we would love to hear from you. We do coordinate with Bernalino County. I know Megan, and that's one of the courts that reaches out and works with us. And I love working with you all. Last time we got together a couple months ago, she had your provider of insurance for your children and our provider of insurance in Arizona, Mercy Care, got together and presented to us about how to get past those insurance hurdles that drive you crazy when you need one more, you know what I mean, right? Service and you can't get it. So I just want to reach out and say thank you for that. And finally, Montana, we do have Pasco Yaqui Tribe is a real great resource if you just want to hear about things like the Memorandum of Understanding. We don't have a state ICWA. We don't know if we will get a state ICWA. It's been attempted and it's being attempted. But that Memorandum of Understanding that the Department of Child Safety has with Pasco Yaqui includes that they have to confer on the permanent plan. And it might imply deference to the tribal before change of case plan and case. So that's a big piece. So I just want to share those things.
Thank you.
Thanks.
For that. Did anyone else on the panel have any additional things to say?
I just wanted to share a quick story. Lindsay talked about family finding in Washington for a while, worked with Kevin Campbell, who did family finding. And I think, many people in Montana might recognize Kevin Campbell from the documentary Place to Place that was done on the Montana foster care system. But he shared this story with me once he was in New York, state of New York, doing a family finding training, and asked the state child welfare workers there how many Native American children they had in their system at the office that he was presented, and they said none. And he was shocked, and he said, "Do you ask?" And they said, "Well, no, but I don't think we have any Native American children in our system." And it was just an eye-opening experience that somebody like the state of New York could have that view of their child welfare system. So just a quick story there.
Yeah, just a simple question might do wonders. Yeah, thank you for sharing that. Okay, so I think we've got 20 minutes or so for Q&A. If you would like to just use the little raise hand button at the bottom of your screen to do that, you can go ahead and utilize that and ask your question verbally, or you can put it in the chat. I do see one question in the chat that was for Lindsay, I believe. And it's from Steve, who says that he loves the out-of-placement preference staffing that you talked about that occurs every month, but he's also curious if there's an initial staffing at time of removal as well. And then would these staffings be available for children that are ICWA determined, but also as well as those who are reason to know, I think is the term for Washington. So Lindsay. Can you address that?
So I am not sure when those staffing start, but I am the one in our county that does almost all of the, we call them custody hearings, they're 10-day hearings here, that initial hearing, that probable cause determination. And from the very, very beginning, we are pushing those out-of-state preferences. I will tell you those out-of-placement preference children, why? And we have a lot of protections on that. So the first is that our law does not allow children under the age of 3 months to be placed out of placement preferences. So our law says they shall be placed within those preferences. It also we have statutory preferences, but if a tribe has their own sort of hierarchy of placement preferences, that trumps our statutes. There was, anyways. And then I will say that if the children are placed out of placement preferences and there is challenge as to whether or not there is good cause to deviate from the placement preferences, then there is a hearing held within 30 days where CYFD has to put on evidence that there is good cause to deviate. And that's usually held in front of the judge, not in front of the hearing officer. And so the court and the law has a lot of protections on that. I will tell you, because those are CYFD internal staffings, I don't participate in those, and I don't know how helpful they are. I don't know, if it's the same people looking at each other every 30 days saying anything new. I mean, I don't know how beneficial they are. My guess would be it depends on who's on that team at any given time. And, but there is a tool that they are using that they go through. I shouldn't say a tool, maybe like a worksheet that they're using. Here in New Mexico, we have what is called a Kevin S. settlement based on a significant lawsuit that was filed on behalf of children in foster care that touches on different cornerstones of our system. But one of them is ICWA protections for Indian children. And so I believe that the worksheet that they use, it's not part of the settlement, but it has been distributed through some of the, I'm going to just call it like progress reports that come out from the co-neutrals who are monitoring the settlement. So that was a long question and I spoke, I don't know if I've touched on all of that, but those placement preferences, if they are out of placement preference, are supposed to happen every 30 days, beginning from the very beginning of the case.
I think the only other part maybe is around, so is it for both the ICWA determined children and also the sort of reason to know children?
Yes.
Okay.
So, and our lesson, if a child if there's reason to know, then until there is a determination, it is to be treated as though it is ICWA IFPA. And so they are included, yes.
Okay, fantastic. Thank you, Lindsay. Okay, the next question is for Judge Bostwick from Cindy. It says, what are the parents' roles in parenting if a traditional adoption occurs? Are all parents legally collaborative, like a shared custodial arrangement?
Thanks, Cindy. I believe the answer to the part about collaborative arrangement is yes, but all I know with regard to their roles is it depends on the community and culture of the tribe. So the cases we've had with traditional adoptions have been from the Gila River Indian community, which is between us and Phoenix here, and their tribal court, their children's court. And what has happened here is we've kept our case going. And sorry, time standards, but it was very important so they could go through this beautiful process of keeping the children in the community and culture without a severance. And then if we ultimately in the state court grant the termination, it's not the termination, we just, by the time we dismiss our case with their traditional adoption, the family, whoever it is, can get the adoption subsidy under the state. So the point is that there's a collaboration here between the tribal court and the state court. So what I think it looks like there is that, according to Judge Hart, who's a tribal judge I spoke with about it, they do not grant a traditional adoption until it's in family and culture. It has to be someone who's considered family. So it may be the auntie, the grandma, because the definitions of family are not our definitions of family. So as long as they have the child safe with the family and someone who will have contact with the parents, you know, that the parents part of the same extended family, then they may grant that. And they will not grant it until they have that. So we said, well, how often do you grant it with someone that's not part of the tribe or not that community? She said, never, we just wait. So very interesting. So I think it works well for them. I believe the Navajo Nation might have that. I don't know if they do. That's the only tribe that I worked with where we actually saw that happening. So that's the most I know. Happy to connect anybody with Judge Hart if you want to learn more.
Judge Bostwick, I would say that we have some pueblos that will not consent to adoption, state adoptions where parental rights are severed, but will do customary adoptions as well. We have some pueblos that will do something similar.
Oh, that's good to know. We are trying to incorporate a few tribal traditions into the courtroom when we do adoptions, when it's an ICWA child or a child where the tribe's present, so they can come in and do a blessing or such as that, and that's great. I just want to share as an aside that when we talk about length of time in care and ICWA processes and all that, when we have come to severance, at least in the cases I have, so yes, as you say, purely anecdotal, but when it's the tribes that have been active in the case from the beginning, and we've allowed the time for active efforts, and the parents are participating, these are contested. So far, although it's been a close call here and there, so far the tribes very actively involved have always supported severance. And I think that's interesting. And each time we have had it with and I'm talking about placement that's out of compliance, but there's good cause to deviate. And each time that tribal social worker has been in that children's home and they have been giving them cultural services, they've been showing them how to cook traditional foods, and the non-compliant placements have been taking them to cultural events and involving them in learning the language. And as well, as you said, cultural compacts are included, Navajo, Tohono O'odham, and Pasquayaki. So I just mentioned that I think long time in care, sometimes, although we don't want it, we try to avoid it. It really sometimes leads to knowing, beyond a reasonable doubt that continued custody won't work and that this is the right thing, and hopefully keeps them in, touch with the tribe and other family.
Great. Okay, I don't see any more in the chat. Does anybody in the audience, would you like to ask a question by raising your hand? Oh, okay. Brooke, you could have just raised your hand and asked your question, but I'll read your question for you. So for Lindsay, we're back to Lindsay. Can you please share more about cultural agreements or the cultural compacts maybe, and whether adherence to those are monitored prior to final disposition of the case, discussed in court or family meetings or elsewhere?
So I will say that I don't personally know a lot of, first of all, they are done between the tribe and the family. So the court's not involved in drafting that or what they need to contain or anything of that nature. It's not part of like a what we call family center meeting or team planning meeting or any of those like standard meetings that we hold with the agency. It is something I do believe, even the one that I said where there was a mediation put together, I don't believe that wasn't a court mediator. That was somebody I think that was selected, approved by the family and the tribe. But I have not seen how that enforcement of that would look, because it's a pretty new concept here for us as part of our statute. But I will say that they are incorporated into the finalization documentation on adoptions and guardianships as the parties approve them. Whether or not like the document, like the written cultural compact is, or just acknowledgement that there has been a cultural compact, that piece has been that piece of the statute has been addressed by the parties. But I think it is something that has really given some peace of mind to our tribes, that the children will have that ongoing contact. And frankly, I think a big piece of it is the tribe being able to let these families know like what that looks like after the fact. Here we have many pueblos that host like feast days and other significant like celebrations that anyone in the community can go to. I can walk on not knowing a single person in the Jemez Pueblo and still participate in their feast days. And so letting them know what some of the cultural celebrations are, what they're for, that they're invited, how to attend, what they should do. I think cultural food-wise, the language is significant, how they can access resources for things like that. And so, but really it is up to the individual tribes and families to come up with that. So like I said, I don't really know what enforcement of that looks like, but I think the process of going through that it is important as well. And I don't know, Judge Bostwick, if you have more experience with that.
I don't know how it plays out afterwards, literally. I did recently have a review hearing in a case where after much angst and effort, very challenging, we did grant severance and the tribe was on the same page ultimately, kind of situation we talked about a minute ago. But placement then was really active in taking this child to the cultural events, and the compact said it was very specific. The child's going to come once a year and to at least this event, and they're going to do this and that. So I haven't seen how it works out in enforcement yet, but the child has been adopted, and at the review hearing, the very last one, I know it was still going on. Everything was going as it had before termination in terms of involvement. I haven't seen it tested later and how enforceable it is, but they sure, in each case here too, really do a good job of working through placement, working with placement on it and getting them started on doing those things well before, the point of adoption. So hopefully it's the family lifestyle and it really does last, and they're not just saying they'll do it. Yeah. That's what we believe.
Yeah, thank you. Okay, and we have a question from Justice Gustafson for Doug. You may have already answered this, but what was the prompting force behind developing the ICWA case review process, and what were the initial steps taken to develop this review?
Yeah, thanks, Judge. And I will say this was prior to my being a part of the reviews, but from what I've been told, that driving force really did come from the tribes. We have ongoing tribal DCYF partnership meetings, and the request for these reviews came from the tribes. In the initial, that driving force, it was around kind of that story that I shared about asking the question. Really, some of those very first reviews were all about, are we even identifying Native American children that are involved in our system? That was really the scope and the purpose of our initial review back in 2007. So the tribes made the request. We put together the review, the questions that were asked were developed jointly with the tribes, and then those cases were reviewed as a joint partnership, tribal partners and state partners, both reviewing the same case and being collaborative in those answers.
How is that funded? How is your group funded?
So part of the funding comes from Casey Family Programs. So one of the things that I mentioned, it is having tribal social workers away from their tribe for an entire week is a huge hardship for the tribes.
Right.
Even, many tribes are small when it comes to their social service department, and might only have 1 or 2 social workers for the entire tribe. So for that one person to be away for a week is a huge hardship. So traditionally, Casey Family Programs have supported the tribes in attending those reviews by paying for their hotel room and their per diem, and the state has paid for their mileage or their,
So, but you're paid for, like, all of the people that participate in this from the state, you are employees of the county or Washington state, right?
Correct.
Okay, and so, well, see, that's part of why I was asking about that is we have difficulty getting, approved for more FTEs to do anything. And so it seems to me that that program of your ICWA review would really help with identifying, at least on a preliminary basis, to long stayers and cases that have fallen through the cracks, and then having some way to ongoingly, make sure just even court processes are functioning well. But I haven't been able to find the pot of money
Yeah, yeah,
to do that.
from the state side, there's a request that goes out to each of the 6 regions, and that regional administrator in each region identifies the 10 or so people that they put forward. And yes, it's a commitment by the state as well to that their worker is the supervisor, the worker, that program manager from the state side is also away from their desk for a week. So it's a hardship on that side as well, but it's a commitment that the state has made to the process.
All right.
Okay, I think we have time for one more question. Does anybody have a question they just like to ask? Oh, Judge Bostwick?
Question, I'd like to see the questions, Doug or Corey, if you share them, and if they're in the chat, I don't know it, that you ask about the reason to know, especially you said there was tribal input on what questions to ask. It would be great to see those. We do have a reason to know, like flow chart here, so the judges, when it comes into a courtroom, will ask questions to say there's reason to know, or it is ICWA. But if that's available, I'd love to benefit from it. So you can let me know later. Thanks.
I think if there's specific questions, one of the changes that was made this summer around the practice and policies and reason to know is also when those questions are being asked of families. So that's at every case transfer. It's being reintroduced and re-asked to families. So hopefully we're really like the encatchment is complete, I think is the idea, and that there isn't anyone that like gets missed or, so there's lots of people that are going to be checking in and following up, that I will try to find some specific questions for you on how they're doing that.
That's an excellent process. Thanks.
Yeah, and I will I'll find our 2019 ICW review questions and drop it in the chat as soon as I can.
Okay. I think there are no other questions at this point. You all did fantastic in terms of time. Your sections were awesome and right on time. And I'm just so grateful, Corey, Doug, Lindsay, and Judge Bostwick, for your help in providing this information, putting this together, all the prep calls we had. It's a lot of your time. I'm asking for a lot of your time to be on this panel. And so the fact that you were so willing and so supportive of doing this, I can't thank you enough. So again, thank you all for joining us today. I know some of you have actually even been listening in on all the other panel and sessions too. So we just really appreciate you, and hopefully we'll be in touch for other things. It just was so good. I just am like, okay, I'm making a Rolodex of these folks to invite them back to other meetings. But thank you again for joining us this morning. Okay, and then Justice Gustafson, the next thing here is a break, and we're supposed to come back together at 10:30. So if there's nothing else, do you have anything else before we break?
No, I just would reiterate what you've already said and thank the panel members for their time and all of the valuable information and interesting things that are going on in your jurisdiction. So.
Yeah, awesome. Okay, then we'll see everyone back at 10:30.
All right.
Okay.
Thank you all.
Thanks, everybody.
Take care. Goodbye. Thanks, Kim.
Thank you.
Hey, Kelly, should I wait till everyone gets back and then throw everyone in?
Yes, yeah, because there will be some instructions
Okay,
that
perfect.
we need to share beforehand.
All right,
And
no
Justice
worries.
Gustafson, are you there? She must have stepped away real quick.
Yeah.
Okay. Because I did want to say one quick thing about data before we go into our breakouts. But I'll catch her when she gets back.
All right, no worries. Yep.
Okay, thank you.
Yeah. I think it's going good.
Yeah.
I want to talk to you if it's possible about
This is Kevin. Yeah. But
Kevin, you're not on mute. This is Brooke.
thanks, Brooke.
Mm-hmm.
Brooke, I'll get you moved as soon as I have everyone join, okay?
That's fine.
Okay.
So Justice Gustafson, are you there? Okay, right before the group breaks out, I do want to address the data a little bit. I just need a minute, because I know you were saying that some folks
Yeah.
data was old. But in fact, I think we just didn't explain that very well. So I just wanted to explain that real quick in case they refer back to their data.
Oh, all right. Well, I have 10:30 now, so we'll go ahead and start back again. Before we go to our breakout groups, yesterday some of our groups talked about their data and perception that the data that we provided was maybe outdated to some extent. And I think, Kelly, you have some information on that or would like to better explain that situation so that we're all on the same page.
Yeah. Just in case people are wanting to go back to some of their team level data before or at the breakout sessions. I just wanted to let you know. So I know you see where it says like 2019, it ends at 2019. And really what that is it's cohort data. So we use a cohort model because it's the best approach when wanting to ensure that the same events happen to children through the system. For example, same policies, practices, community events, etc. If we use an exit model where we're just looking at 1 year, then we don't know what's different between kids who entered 19 years ago versus somebody who entered a year ago and exited in 2019, right? So it's not actually kids who entered or exited in 2019. It's that the cohort who started in 2019 then reached permanency 3 years later in 2022. That's the data that we're looking at. So it's in effect kids who reached permanency in 2022, but we follow the 2019 cohort for 3 years, for example, for kids who are, 36 months or over in care. So I just wanted to make that distinction because I don't think we did a very good job of explaining that before we gave that data to you all. So there you go.
So in a nutshell, it's more updated and reflects and does reflect some of the practices that courts have been involved with over the period from 2019 through 2022.
Correct.
Okay, so that makes maybe better sense. So at this time, we are going to go to breakout groups. And again, we'd like you to pick somebody to be who will report out at the end, and maybe somebody who will take notes. And we really are interested in, what thoughts or ideas did you hear over yesterday and today that resonated with you, or you thought was particularly helpful, or that you could use in your own work? And then we really would like you as a team to identify things you could, at least one thing as a group you could do, or you think you could do to improve permanency, and one thing you could do individually in your work as well to improve permanency. And so I guess, lack of better terms, action planning as to, how are we going to take some of what we've talked about today and make it relevant to what we're doing and to help us in the work that we are doing moving forward. So we're going to go ahead and go into our breakup groups. Kelly, or Julie, did you have anything more to add before we do that?
Nope, we're ready.
Hey, Justice.
All right.
And this
Oh,
is
yeah.
Kevin. Hey, I'm going to open the rooms for everyone. And if we have a little mess up like we did yesterday, where there's a lot of people that didn't get assigned to rooms, I'll just go down the list and add everybody. That's probably the easiest thing to do. Okay. So,
Okay, yeah,
FYI.
great.
okay, so I'm going to open all the rooms. Okay, Amy Lord, do you want to tell me what room you want to go to?
They're judges, they're associated with judges, right?
Yes.
Judge Halligan. Judge
Okay.
Halligan is the room that
Okay. Austin Wallace.
Judge Halligan, please. Thank you.
Okay. Brenda Kirkley.
Judge Berger, please.
Okay. Brooke is going to Fair. Julie
Judge Berger?
Berger. Okay. David Lord.
Judge Halligan.
Gail.
Judge
Berger.
Halligan.
Okay, thank you for not making me pronounce it. Justice Gustafson, you going back to best?
Sure.
Okay. Ivy.
Judge Halligan, please.
Lindsay Burner.
Judge Davies, please.
Lisa.
Judge Whalen?
Melanie.
Judge Harada.
And then Marcella.
Is that Michaela?
Or Michaela, I'm sorry, yeah.
Judge Best?
See, there's no order there. All right, Mick.
Judge
Mick
Parker,
Larry.
please.
Okay. Rachel.
Judge Best.
Shannon.
Parker, please.
And Goodman.
Judge Davies.
Thank you.
Thanks, Kevin. I'm just gonna stay here and take care of some other things. I'm not gonna go.
No problem. No problem. So
Are there people? Are there actually people in the presenter panelist room?
there. Let's see here. I don't think
That's
there
where.
is, I think.
Okay, because I originally got us
just
to that.
you. Yeah,
Okay.
no one in tribal or yeah. And so yesterday, I don't know what happened with the Zoom, if you got a second, but
Yeah, no.
something happened, and I honestly think I actually have a support call in with Zoom on this, but my second invite, or the second part of today's meeting actually went away out of my calendar, and
Oh, no.
it was just really bizarre. And so the Zoom guy actually put in a service ticket with Zoom, and but the more I think about it, is I wonder if it's something that maybe I did, because Outlook Calendar is so attached or tied in with Zoom that if you put it in Outlook Calendar, it'll remove it in your Zoom too. And maybe that was an issue. I don't know. It was a really hard one. And so people had to re-register yesterday morning, as you'd know.
Yeah.
And then when I broke out into the rooms, I had like 40 people that weren't assigned a room. And I don't know why that is, because I polled everybody the night before, like at 9 o'clock. And so I had like 106. So and it's just an email into the room. So I don't know why, if something happened with the email, I don't know. Anyway, real crazy, but
yeah,
much better today. I think I had like 16, so which is common.
Yeah.
Okay. No problem. And I'll send out, so this goes until 11:10. So at 11:05, I'll give them a 5-minute warning.
Great. Yep.
And then I'll give them another warning at 11:07. A 3-minute.
Yeah. Okay. That sounds great.
Okay. Thanks.
Thank you.
Bye.
Okay.
Dun, 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 dun.
Cody, did you want to join a room?
Oh, sorry. No, I had to log off to go to court. I'll log back on. Thank
No
you.
worries. Yeah, how about Eric? Did you want to go to a room, specific room? Lacey? Laura? Judge Rieger, do you want to go to a room or do you have your own room?
All right. I think we have everybody back, and I don't know about your groups, but the group I was in had a rather robust discussion on what we could potentially do better. I guess we'll have a few report outs. So I don't know if anyone from Judge Berger's group like to tell us what you talked about.
No, Justice. Of course, you'd pick me just as I was forcing some of my lunch into my mouth.
Oh, shoot. That's all right.
So we have the benefit of working with Judge Berger, and of course, he was part of the pilot program for rural counties and these pre-hearing conferences. So I have cases from Havre to Dillon, and I know all the courts are a little different, but for Judge Berger, I think everything is really working super well. But in regard to the questions and some of the topics that came up in the discussion, I know personally, as a state's attorney, I have very little interaction with the tribes in the cases. At least I've traditionally delegated most of that interaction to the social workers, and I can certainly work on having more predispositional interactions with the tribe, perhaps group staffings, to make sure that the tribe is involved as they wish to be, and so that I'm more aware personally of what the tribe in each particular case is up to. And I can certainly improve on that as an attorney. We had discussions about the CASA being more involved, again, with the tribal representatives and the qualified expert witnesses. That doesn't appear to really be happening in the 5th Judicial District. And again, more exchanges of information, I think, are a good thing. And CASA would like to be involved, and I think we'll probably work on getting that done. We had a nice discussion about the possibility of including QEW affidavits as opposed to direct testimony. I know it's common in all of the jurisdictions I work in to have affidavits read into the record subject to cross, and I know there's some people that are kind of hand slapping about that practice, even though it does speed up the process. I think having the QEW's information out to Defense and Youth Council ahead of time is a good thing. It gives them more time to discuss with their clients any questions that might want to be asked and help them prepare for that. Of course, having both the social workers available with affidavits read into the record and QEWs available to answer questions for those parties at the hearing anyway would be appropriate, to not trying to use affidavits to keep people from coming to court. We also had a nice discussion about the idea of cultural adoptions and what form that might take within the state, given the current state of the legal system and the laws that are in place. I think it's a great idea, the ability for the tribes to take control of the ultimate destiny of their kids and their family and their culture. I think the ability to interact with the tribes in a way to make that happen would be great, fascinating. I know oftentimes, it's not unusual for us to put an amended parenting plan next to a judge, next to a dismissal in a DN case, and sign one, sign the other, and call it good. I'm sure there's some mechanism that can be worked out for that to happen with the tribes and the tribal courts. Apparently Arizona and New Mexico have made that happen. It would be neat to figure out how that happened and perhaps explore that a little bit and implement it. And in permanency in general, I think we just emphasize that it's important to have communications about concurrent plans as soon as possible to really work on those permanency plan teams and getting that information out to the parents and families so that we're not dragging our heels when it comes to what happens if a parent falls off the cliff and there needs to be another outcome. Just so everybody's aware at the beginning of the cases, and as much as possible to include the family. So all of the resources of the department, the parents and the families are brought to bear by the time we get around to, 15 of 22 months. At least personally for me, that second extension is a trigger for me to really start pushing and exploring why things haven't happened yet and what we can do to speed things up.
So Jim, in your pre-hearing conferences, I'm just curious, Judge Berger, I know he's multi-county. So are all of those conducted by Zoom, or is there a hybrid where some people are in person and the facilitators on Zoom, or what?
No, it's all by Zoom. So
Okay.
what we've set up once a week for all 3 counties. It's all on the same link in Jefferson County, so there's no confusion about what Zoom link to get into.
Excellent. Okay.
We contact the pre-hearing folks. They set it up at 1:30, and we do our APS hearings at 2:30 on Wednesdays.
Right. I was just following up. I wasn't sure if they were hybrided or not. So, how about somebody from Judge Whalen's group?
Sure. So we kind of went all over, but the things we recognized or that we talked about was really how timeliness issues are kind of an issue across the nation. Obviously, the other states talked about it, so that we're not necessarily an outlier there, but really appreciated hearing kind of the different things the other states are doing around that. Also talked about if we focused on tribal involvement, we, potentially will have more likelihood of finding family members. So even if the tribe isn't, if they intervene, or as long as we have some tribal connections, hopefully that would help us find some family members. And then also spend some time talking about how to increase our use of the urban Indian centers across the state, and that could be helpful for our clients.
All right. How about Judge Fair's group? Yeah, I don't know anybody from the Judge Fair's group or Billings groups.
I think Deb Cole was gonna report out, Justice Gustafson. Maybe she got maybe you could come back to us.
We'll come back to Deb Cole. So I know the folks in the Flathead, I know Judge Eddy wasn't able to be here today, but from that group, Judges Eddy or Kaufman's group, anything you want to report out on?
Yeah, so I'll sort of combine these. We talked a bit about how struck we were after yesterday's lived experience presentation, how powerful the desire of children is to be with their bio parents and the lengths that they might go to see them. And then also how a parent seeing their kids and having the visits might be really a motivation in doing the work needed to be reunified with their kids. And so tied in with that might be that there are, in terms of timeline, there are individual situations where maybe a longer timeline is appropriate. In particular, in ICWA cases, there might be an increased reluctance to engage and seek services, and there might be a particularly low availability of services, or it might take longer to get in with services. And so the action items that we discussed were, one, taking a more individualized approach to timelines and looking at what the impediments are for parents and whether they might need a little more time. In particular, if there's substance abuse issues, just given that it takes time to successfully go through treatment and recover. It's not, a quick process, even just physiologically. And then also we talked quite a bit about how we can encourage parents to engage in the process and do the visits, even if they're using. We talked about how there might be a hesitancy to go visit when when you're using, because one, there's shame, but two, it's documented. And so we discussed that we all need to really encourage parents and let them know that they're not better off by just not seeing their kids, even if they're using. That's why they're supervised. It's going to be a safe visit, and we want them to see their kids. It helps their kids and it helps them. So that's some of it.
All right, thank you. Anyone from Judge Harada's group?
I can report. We didn't speak very long. I was surprised that we covered everything that we could in just a few minutes, but I think one of the biggest things we discussed was how powerful yesterday was, and you know, the importance of if we can get parents to engage with the placement, because I think there's a misconception that a lot of parents are going to just come steal their children back. And I think we talked specifically about one of the cases, I think in my courtroom, where the mother did really, really well, but developed a very strong bond with the placement, and then was able to utilize the placement for respite care, and then, you know, additional support services, and just really kind of became a part of that family. And then when there was a re-removal, unfortunately, that did happen, but the child was able to go back to that original placement, and it gave everyone a better sense of what to expect. It wasn't as traumatic for the child. The mother knew that the child was safe. And so we just really appreciated the ability to maybe utilize the placement as a resource. We did discuss also how important that sibling bond is, and sometimes we overlook that when children are separated from their siblings, and we're going to try and pay closer attention to that. You know, really, we have these amazing family engagement meetings in Yellowstone County. We have amazing pre-hearing conferences before our EPS hearings, and those are just run incredibly well, and we are going to take advantage of those as often as possible, without hopefully wearing people out. Mr. McCann did say that he thought it would be helpful if attorneys for the parents had more information earlier, and we all agreed with that. It's just hard to get that information sometimes. And so we talked about, you know, what's the practicality of that, and that's pretty much the extent of what we really focused on. I have to, again, just say I have a really great team here, and I love working with them, and they do amazing work. So that's
Excellent. All right. Anyone from Judge Davies' group want to share what they talked about?
Sure. I was voluntold that I get to report back. So we had talked about, one of the things that struck us was the New Mexico list to do non-preferred placement staffing specifically. We certainly do our monthly staffings with our tribes, but just being even more purposeful about today's staffing is about the kids who are in non-preferred placements and what next steps could be, or who we could better connect them with. We also talked about in our, specifically Bree, who does all so many trainings for new workers, but also for all of us who do trainings to certain extents, bringing up timelines earlier, so that as we're training workers, or even like training attorneys, or Brooke and I do a lot of QEW trainings, just bringing up the timelines again, and you know, being clear that kids can't sit on shelves. And then the other thing that we talked about was in the treatment court settings that usually we're so focused because kids are going home, that additional family members, it's sort of like the search for family ceases. And so being more purposeful about connecting kids to families and continuing the family search just in case there was a re-removal or additional supports for the family. So those were the primary things we talked about.
All right. Well, I sat in with Judge Best's group, and the family placement issue is certainly a big deal as well. Sarita, maybe you want to talk about what the group discussed?
Yes, I will have Michaela because she's right by the computer.
Oh,
right behind
okay.
her. So I think one thing that came up was that following that New Mexico, I think it was the out of placement preference staffing for our ICWA cases, and we could get some good use of that here in our jurisdiction when we do have children placed outside of the placement preference. We really appreciated some of the active engagement that we have seen and heard about from some tribes in some other states, and we're really working hard in our jurisdiction to try and gain that same momentum to get more tribal involvement early on in a case. And then that kind of piggybacks the pre-hearing conferences that we're no longer having in our jurisdiction. We had them in 2 of our courts for quite some time. And then when the EPS hearings took over, those pre-hearing conferences have somewhat fallen by the wayside. And if there's a way that we can potentially get those back in place, I mean, they're still available, it's my understanding, to parents who request them, but they're not kind of an automatic implementation anymore. And that was a good place to where parents could feel supported and heard. They could have that contact with their attorneys, and we can start cases with those productive conversations about family placement and who else we could be looking for and exploring for potential placement to support these families. And then also trying to make these as accessible as possible to the parents in our jurisdiction, because doing them by Zoom, because we have not had a facilitator in our city, in like Great Falls, for example, and doing them by Zoom, not all parents have that capability to be able to attend something by Zoom. And that's kind of creating a barrier at times for them, to maybe where we could have something set up in a courthouse or somewhere mutual where there's that link accessible to them to be able to attend.
All right. Thank you. And anybody from Judge Rieger's group?
I can.
All right.
Good morning or almost afternoon. So we talked about a lot of the same things that everyone has already said. We talked about how important the lived experience presentation was yesterday, and how that's really stuck with a lot of us. We talked about encouraging foster families to work to develop relationships with the birth parents. We, you know, how do you balance the attachment that foster families get with these kids? I think Scott said it best, you know, if you do it right, you're going to end up getting your heart broke, getting them home, and avoiding maybe the us versus them mentality that, you know, needs to change, such as the gentleman said yesterday, which led to, you know, training and education for fostering children to support the parents. We also talked about diligent searches happening immediately for family, finding family so that kids can get connected to their actual family. We also talked about kids seeing their parents right away and moving towards a quicker move towards unsupervised visitation in a safe way. You know, we're going, and I think Cindy said getting ice cream or, you know, going to a basketball game is normal and safe, and, you know, people around, safe environments, and how parents don't always feel like when they're supervised visits that they're anything except for maybe a test for the caseworker or the supervisor to write down everything that they do wrong, which is not what we want them, you know, to be feeling. We want them to be working on their time with their children, which is important. We also talked about changing the philosophy on addiction, you know, how it's a long-term, lifelong issue that people who are substance use disorders last for forever, essentially. And how the department can't remain involved forever. So how do we get parents involved in services right away and I think that's where those pre-hearing conferences really are beneficial. And it's sad. It kind of saddens me to hear, because I've enjoyed having them, that Great Falls is not doing them. They're just so important. And then involving the foster parents in the court process so they can see the importance for the child to support the parents. That's overall, I guess, what we talked about. So if we're working on a team approach, we really need to involve the foster placement in that team so that they can understand and see that parental success doesn't mean foster parent failure. It actually means really good success for the foster parents and the child. So,
all right, great ideas. So, and I think the only group we haven't heard from now is Judge Halligan's group. Anyone?
Yep, can you hear me or see me?
Oh yeah, there you are.
So we also discussed many of the things. We didn't focus on the ICWA cases quite as much in our discussions this most recent time because we have an ICWA court and many of our cases go there. But we really focused on trying to have permanency discussions a little sooner to engage in more of that support as a kind of a village for the parents. So if this were to happen again, you know, who would be the folks that you would look to for support and to have it a little less adversarial? Of course, we all know that sometimes those relationships are adversarial within that group, and sometimes that is a barrier. But we talked about having earlier discussions with regard to permanency to also flag when we're filing perhaps extensions of temporary legal custody, that opportunity to then have and remind parents of the timeline concerns that we might have, just to keep that on the radar and also to help identify other barriers that might be presented at that point that, you know, might be something new. Hopefully these earlier meetings will help to engage the relationships as well. We spoke a little bit about moving or trying to encourage our kinship placements and other placements to get licensed sooner. We're running into barriers where a placement that's, you know, been involved since the start of the case but has not been licensed then has a kind of this burden of licensing that comes later. And it also affects then the timelines that 4E funding mandates for kind of supervision in that placement for 6 months. So a child may have been already 6 months in that placement, but we need to extend another 6 months, which also extends that permanency timeline. So we all agreed to begin those discussions earlier and to express to those placements that merely becoming licensed isn't necessarily a commitment to long-term placement, but would facilitate longer-term placement if it happens to be the case and wouldn't necessarily kind of steer us away from reasonable efforts to reunify as well. And then last week, we talked a little bit about how the permanency plans are really structured. And if in fact we're doing the parties, I guess, some justice when we're continually emphasizing reunification when perhaps efforts haven't been really, parents haven't been engaged in reunification. And sometimes how difficult that is for children to continue to not have their preferred placements really acknowledged as a primary focus for permanency. That might be guardianship or some form of adoption. And I welcome anyone else to add in, but we are working to try to look to see if we can reduce those kind of longer term cases.
All right. What a bunch of great ideas we've heard today. So it's amazing to me all of the things that people come up with when we actually sit down and have some time to talk with each other, as opposed to, I know everybody is very busy and it's hard to take this time, but we do really appreciate your engagement with our training and really committing the time to sit down and talk with the folks that you work with about how we can make things better. We are on time, we're a few minutes ahead. I think some discussion on evaluation, maybe Kelly or Julie, or is
Yep.
there something we're doing there?
Yep, that'd be me. So in an effort to hear from you before you all take off, so please don't leave. Please do this evaluation. It's always easier to do it this way than to send out a survey monkey and get maybe 40% of you responding. But we really need your feedback to make these moving the dial trainings as effective, worthwhile as possible. Your time is very valuable, so we want to make sure that whatever we do during these 2 days is helpful to you. So please do take a moment to do this quick, it's basically a poll via the Zoom, and Kevin will put that into, I don't know, where's Kevin? Kevin will put it up. Yeah, I think so. Yeah. I think we can launch it. And yeah, if you would just go ahead and take some time to do this.
And I would ask maybe our planning group stay on for just a few minutes so we can have just 5 minutes to wrap things up among our planning group. And I suppose others, after we take the poll, can log off, right?
Yes.
Gustafson, I have one more thing too.
Yes.
For the attorneys out there, I did submit a CLE application to the Bar Association. They haven't approved it yet, but they have all the rest. So if you would like CLE, please email me your state bar numbers with the number of hours that you attended overall. And then when I hear from the plea commission, then I will submit your names and bar numbers to them. So thank you. But
All
it
right.
probably is going to take a while. I think they're backlogged, so it's not going to happen quickly.
Once again, I just want to thank everyone for coming and devoting the time to this, and to really appreciate all the input that we've received, because it does help us work with different groups along the way as well. So thank you again for coming, and please take the evaluation, and then we'll let you get going with the rest of your day.